Well, we've certainly covered a lot of ground today. I think it would be important if we can give our viewers some examples of some of the lawsuits that maybe you're currently involved in. Let's start with you, Kenan.
Milton, Ted and I spent a lot of time on the Ronald v. Bank of America case, and Ronald is the granddaddy of these mass joinder cases. As the granddaddy, it started in 2009, but it really is the case that has trailblazed the approach of trying to protect homeowners by looking at what's happened and by trying to make them whole. And the Ronald case alleges that the banks concealed and affirmatively misrepresented what they were doing in providing mortgages, that the banks really were no longer providing mortgages as mortgage lenders, but were now giving mortgages to borrowers, treating them like pawns or like fodder for the sole purpose of getting these mortgages and selling them on to investors, and not telling the truth to the investors either about what they were doing, that the banks, it's alleged in this complaint, just ignored their underwriting standards. And this case is really about what Countrywide Financial is alleged to have done from about 2004 to 2008, and then what Bank of America is alleged to have done after acquiring Countrywide at around that time. We've also have in the complaint allegations for some of our plaintiffs that the banks didn't follow their proper procedures. We have allegations involving violation of our clients' privacy rights. And we have something that's very important and is unique to California. It's called an unfair competition claim. But what it really is not really about unfair competition. It really says that a defendant who has done something that is otherwise unlawful or unfair or involves false advertising should have to give back to the victim of that any benefits they got from that. And that's different than damages. So we've alleged the bank should give back all the interest payments and all the fees that they earned from doing this. And the Ronald case, it took a while to get what's called a good complaint on file, but the court in the Ronald case has come to the view that we've stated valid and good causes of action. And that doesn't mean we've proven our case, but it means that our trial court judge does believe that the bank should be made to prove it didn't conceal, didn't commit fraud, didn't fail to follow the right procedures, and also that the bank should prove that it has the right recorded loans, that the right assignments, and I guess technically we have to prove the bank doesn't. But the point is that the bank now has to come in and litigate on the facts of this, and it's no longer going to be able to hide behind just pure legal defenses of we may have done it, but it doesn't matter, we're a bank, we can do what we want. And that's just not going to work in the Ronald case.